Now, let us take a look at an attempt at defining attempt. So, many scholars have actually made a lot of effort to bring out various elements of attempt in their definitions. However, the IPC does not provide a definition of attempt in the Indian Penal Code. So, in this light, it will just be pertinent for us to take a look at various scholars and their definitions of attempt. So, for Stephen, there are few steps which need to be present and few elements which need to be present for attempt to have been there. The first important element is the doing of an act in furtherance of an intention to commit a specific crime. Secondly, such acts should form part of a series of acts which taken together and if uninterrupted, and this is the point which needs to be emphasized, if uninterrupted, would lead to the actual commission of the crime. Impossibility of actual commission of a crime does not have an impact, according to Stephen, on acts which qualify as attempts if the aforementioned conditions are satisfied. Finally, an attempt can be made even if the offender voluntarily desists from committing a crime. Likewise, a leading scholar, Halsbury, has also stated that attempt has three primary elements. First and foremost, there has to be an overt act which is immediately concerned with the commission of a crime or an offence. Such act should be done in furtherance of a guilty mind, and the overt act should form part of a series of acts which, in the absence of interruption or frustration, would end in the commission of the actual offence. Andrew Ashworth likewise highlights two important elements in attempt: the fault element, firstly, which refers to the guilty mind or intention of the offender; secondly, the element of conduct, which refers to the minimum conduct necessary to qualify as attempt. So, when we take a look at each of the definitions provided by Halsbury, Andrew Ashworth, and even by Stephen, few things come out very clearly. First and foremost, when we discuss attempt, the most important thing which is to be present and which actually links it up with the commission stage or the final stage of an offence is the presence of an intention. But the mere presence of an intention does not make attempt punishable. So, along with the presence of an intention, there has to be an act which is in furtherance of the intention and progresses towards the stage of commission of the offence. Now, this is where attempt is said to have been committed, or the inchoate offence of attempt is said to have been present. Now, having understood the various elements of attempt as highlighted by leading scholars of criminal law, at this stage we should also try to answer a very important question in criminal law, which is at what time or what point of time does attempt begin and where does attempt culminate. So, this is something which has perplexed scholars of criminal law for a very long time now. So, at what point of time does the offender do something which we can actually label as more than preparatory, or the link between preparation and attempt has always been confusing, because it is very difficult to make out at what point of time preparation ceased to exist and at what point of time it qualified as attempt. Further, there may be situations where attempt and preparation may actually blend into each other, making it very difficult for us to isolate one from the other, and it is then that the issue becomes even more complicated. So, whether an act has reached the stage of attempt or was merely preparatory, it becomes the matter or the subject matter of a very bigger debate in cases where an attempt has been interrupted at some level. So, imagine a scenario where somebody pulls the trigger, gets the gun and pulls the trigger and tries to shoot at a person. Now, if you look at the three successive stages of actus reus here, where exactly would you say that the person ceased to prepare for the commission of the offence and actually went a step ahead and entered the stage of attempt? So, this matter becomes particularly difficult, as I said earlier, in cases where attempt and preparation seem to have blended into each other or seem to have faded into each other. In these circumstances, the litmus test of determining what attempt is or at what stage attempt began is a very difficult problem for us to solve. So, most scholars opine that the litmus test for identifying attempt or the ultimate test for identifying attempt is to figure out whether a particular act was merely preparatory or a step ahead of the stage of preparation. And the other important thing that we need to ask ourselves is whether the accused engaged in the commission of the crime. So, whether the accused was standing at the threshold of the commission of the crime is a very important question, which probably can lead us to the solution as to whether there was a situation of attempt or it was absent all the while. So, scholars have identified three primary tests for distinguishing attempt from the stage of preparation. The first test is the test of proximity, which has been applied in many cases earlier by various courts across India as well as England. Then we have the test of locus ponipotentia, and finally the test of equivocality. The test of proximity is the first and foremost test and has been used in a majority of cases. It has come to the surface with one primary question: was it the last act that was legally necessary for the offender to do? It is not required that it was the last act which the offender legally intended to do, but what is necessary for us to figure out is whether the act indulged in by the actor, in this case the offender, was the act which was legally necessary for him to do. R versus Taylor is a very significant case in this relation in the test of proximity. Here liability was fixed for lighting matchstick to set fire to a stack of hay, although the offender in this case extinguished the matchstick due to fear of being perceived by someone. In this case, the court had fixed liability on the offender on the ground that the act of lighting the matchstick was proximate enough to the commission of the offence with which he was charged. Along with the test of proximity, we often follow an ancillary test which is called the Rubicon test. Rubicon test had come to surface in the case of Widdowson and in the case of Stonehouse as well. Here the immediate connection with the commission of the offence is what we need to figure out for ascertaining whether a case is one of attempt or not. So, what we do in this situation is we try to figure out whether the last act or the act of the participant or the offender in this case was something which was connected very proximately with the commission of the offence, and if the answer is affirmative, the Rubicon test is said to have been satisfied and the person is held responsible for attempting to have committed an offence. Now, Guffler followed by John's case again have reiterated the principle or the test of proximity, where the accused was indicted for attempted murder, although he claimed that there were at least 3 other acts which need to be accomplished before the offence was actually committed. Now, in the case of Jones, an interesting matrix of facts had surfaced. In this case, the person concerned, the offender, had entered into the car and pointed a gun at the person's head, and in this case he was charged with and also held guilty of attempted murder. Now, the plea which the offender had come up with was this cannot be a situation of attempt, because there were at least a minimum of 3 other stages which had to be passed for the commission of the offence or the actual shooting of the person concerned. So, he pointed out that the pulling of the trigger was a necessary part of it, along with which he said that the target had to be fixed and the actual shooting had to take place. So, in this setup, it was not pertinent for the concerned person to highlight that the opposite side to highlight that by just entering into the car and pointing a gun, he could be held responsible for the commission of attempted murder, because the act was not proximate enough. However, the court had held him guilty in spite of the fact that or the plea that 3 other stages had to be reached, with which the court did not agree. In the case of state of Maharashtra versus Mohammad Yaqub, which is a very famous case in the Indian scenario, wherein the law relating to attempt was discussed, Justice Chinnappa Reddy and Justice Sarkaria had 2 distinct opinions to be presented. So, Justice Reddy pointed out that measure of proximity should not be in relation to time and action, but it should be in relation to intention of the concerned person. Likewise, Justice Sarkaria pointed out a very different opinion in the same context, wherein he laid down that the actual physical proximity of the act is the testing stone for finding out whether attempt was existing in a given scenario or not. The second test is otherwise called the test of locus plenipotentiae. The test that we take up in this particular context is in finding out whether at the stage of preparation the person could have made taken a step back. So, which means that if the accused, in this case it can be shown in a matrix of facts that he had the right to, or he had the opportunity to take the step back or not really lead the attempt to a particular result or accomplish the attempt, this is exactly where locus plenipotentiae is said to have come into operation. So, the test of locus plenipotentiae suggests that the test requires us to be present in a given scenario, wherein the ultimate test is to find out whether or not the person could have taken a step further, taken a step back. So, which means attempt is said to have been committed if the act was such that there could not have been a moving behind or a moving back from the concerned act. Now, the test of equivocality is the third important test which needs to gather our attention. So, if the act unequivocally indicates that the offender intended to commit the offence, this is precisely where the test of equivocality is satisfied.